Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Thomas Christensen presiding.
Good morning, please be seated.
Thank you.
Welcome. We have oral argument before the Minnesota Workers' Compensation Court of Appeals. Today, the date is October 30th, 2023. As you can see, we have a device on the podium in front that is being used to live stream and record the arguments today, and we'd ask that you speak loudly and clearly during your respective arguments. We have a three-judge panel today. On my right is Judge Quinn. To my left, we welcome and recognize Judge Carlson participating in her first oral argument today. And just wanted to say that we are very pleased and happy to have you and welcome you to the court. Yeah, the first case today is file number WC 23-6513, Gerald Bauer versus Flint Hills Resources and ESIS Inc. Appeal from findings and order dated May 2, 2023. Counsel, you've been here before and you understand the rules, but to go over briefly, at 15 minutes, the yellow light will come on at 2 minutes, and it's up to each of you to reserve time for rebuttal. Please be aware that questions from the panel can come at any time. In the past, there was some period of time that we gave you to argue before questions that is no longer applicable. And finally, we'd ask that you, when going to the podium, please identify yourself and your party. And with that, Mr. Borkin, I think this is, you will begin.
Thank you. May it please the court, Joshua Borkin on behalf of the appellant, Gerald Bauer. Counsel, good morning and welcome to the newest member of this court. I would first like to reserve 5 minutes for reply and ask if you have any questions to begin with, or if you'd like me to just proceed with my argument.
Yeah, please proceed.
Okay.
Thank you.
So it's the employee's position that this court should reverse the compensation judge's order denying the ongoing permanent total disability benefits Mr. Bauer would be receiving after he reached age 67. The compensation judge committed an error of law by ignoring the party's stipulation that Mr. Bauer was permanently and totally disabled from working, and by finding that he should have looked for work following his 67th birthday.
Well, let me ask you about that, Mr. Bork. I agree that what Vandervoot says, and so stipulate the PT, whether someone is looking for work really shouldn't be a factor in looking at retirement.
Yep.
Intent to retire. Can we consider, one of your arguments is basically that your client's financial circumstances are so dire that he wouldn't have intended to retire, you know, he had known these things, especially with the co-pays for his wife. Can we consider whether the circumstances are that dire and look at the job search for that reason? And if so, why? And if not, why not?
No. If you're stipulated to be permanently and totally disabled from work, it means you cannot work. And that applies to not just whether or not he's permanently and totally disabled, it applies to any job search whatsoever. And he did do a job search for 1 year, for almost 52 weeks prior to being stipulated to be permanently and totally disabled. And he wasn't able to work. That's why he was stipulated to be permanently and totally disabled. That's one of the reasons. So once you're stipulated to be permanently and totally disabled from work, there's an agreement between the parties that my client cannot work. And so he can't look for work related to his changed conditions. He cannot work. That's why he's been stipulated.
He can look. I mean, he's not prohibited from looking for work.
He's not prohibited from looking for work, but he cannot work.
I mean,
right?
But don't we look at all of the? I mean, when we're considering whether someone's permanently totally disabled, we look at a variety of different things. And one of them is like, what was their wage at the time of injury, and what's the job market, transferable skills, and so forth. So, okay, he's PT. years pass, now he's got a set of circumstances with his finances. And I think it's in the judge's memorandum near the end where she says, you know, if the circumstances were that severe, he would have done something like look for work. Isn't it relevant at least to determining how dire the circumstances are?
I don't think so, because then he's not perm totaling. If you're presupposing that we have to rebut the stipulation that he's permanently and totally disabled, but we don't. Like, we've agreed to it already. And so you're saying, well, circumstances change now, he's no longer permanently and totally disabled. We can't change that.
But people who are permanently totally disabled can still work as long as it's like an insubstantial income or, you know, and like you said, your client did look for work before it was determined he's PT. So,
Right.
And he was PT retroactive. So, you know, he looked for work during restrictive PT in hindsight.
And Judge, you mentioned a significant word in there, insubstantial. And so if it's an insubstantial income, that's the most that he could do because of the Social Security disability rules, that's still not going to recover the difference in the permanent total disability benefits that he's not getting.
Mr. Morgan, now that we're talking about finances, my question for you is, I have a couple of questions. Is financial, what I'll call stress, is financial stress alone enough to rebut the presumption?
I think you still go through all the factors that were listed out in the SCARI and make a determination based on that. But I think the financial stress is a big factor in this case. I mean, you have a situation here where he's paying $3,500 for these Skyrizi injections for his wife, and he's no longer on his employer's health insurance. So that's a big financial stressor.
Well, so let me ask you this. My understanding was that the out-of-pocket prescription expense was, I think you said $3,500 every 3 months, correct?
Correct.
Okay. What degree of financial stress do you have to prove then to rebut the presumption? Is it, you know, you have to budget a little bit more? Is that enough? Or do you have to show some level of hardship or inability to pay basic household expenses?
Yeah, based on the compensation judge's finding, it seemed like he had to be destitute in order to qualify to rebut the presumption. I don't think it's that level. I think if you change your financial circumstances because you're not receiving those permanent total disability benefits, that shows that you have significant financial stress, sufficient enough that you would have kept working past age 67. And in this case, it was cashing out his pension in a lump sum that shows that it was significant financial stress. And it was the new expense of his wife's medical expenses that showed that he had significant financial stress. So I don't think you have to wait till he mortgages his house or he becomes evicted from his apartment or whatever in order to satisfy that factor.
Do you agree that the only change in his finances since the stip was this additional prescription expense?
I don't think that's the only change. I mean, he had his son continuing to live with him, which becomes a financial stressor. And he he didn't have his health insurance anymore. So it's not just those medical expenses, it was other medical expenses as well, his own, in addition to his wife's. I think the not being on the employer health insurance anymore once he turned age 67 was a big deal as well. And the permanent total disability benefits helped offset that cost.
Wasn't that part of the plan though? I mean, if we assume pre-injury, that he was thinking, well, my plan is to retire at 67 because then I'll get on Medicare. So the presumption was that he would stop being on that insurance around that time.
Well, he would have kept working. No, I mean, he would have kept working if he hadn't been injured.
Agreed. He would have kept working past the date of injury, but didn't he testify something to the extent of, and before I got hurt, my plan was eventually I will retire, probably around age 67.
Right.
Okay.
But then
he had off insurance then.
Correct. But then he had his wife's medical issues.
Right, I understand that part.
And then he changed his mind about when he would have kept working.
Right.
So,
in looking at the situation, it's my understanding, at least from the transcript in the briefs, that Mrs. Bauer is receiving Medicare, that's her health insurance at present. Is that the same for Mr. Bauer as well?
Yes.
And then somewhere along the way, I assume, given the age of Mr. Bauer, he was on Social Security disability benefits. Have those now changed over to Social Security retirement benefits when you turn probably 66 and a half?
I would assume it has. I don't know for certain. He is 68 now, so yes, I would imagine.
And then kind of along that same line as to the financial part, are they still about $1,000 ahead each month, or has that changed from the time?
I think that's about right, but I don't think that's a lot. That leaves almost no money for savings. It leaves no money if you wanted to buy a new truck, you can't do that. It leaves no money for any sort of emergency. It leaves no money to, help support the son get out of the house. It's great that they have that amount still being saved or whatever, but that is a significant departure from what they were accustomed to making prior to the work injury. So our position is that if the compensation judge put any emphasis on the failure to work or look for work, the findings in order clearly show that it was a big factor in your determination, then you have to reverse it. The stipulation that Mr. Bauer is permanently and totally disabled, that's res judicata, that's the law of the case. Parties entered into a stipulation for settlement. It was signed by the same compensation judge who approved or who presided over this hearing, and she agreed that Mr. Bauer was no longer capable of working. Our conceit is this. Our position is this. It's very simple. If you cannot work, you cannot look for work. So it's a clear error of law by finding that someone who is stipulated to be permanently and totally disabled can look for work. By making this finding, you're ignoring or relitigating the previous stipulation. That's a clear error of law. You can't distinguish Vanderpoort without ignoring that the parties stipulated that Mr. Bauer is permanently and totally disabled. Whether Mr. Bauer is still permanently and totally disabled is not an issue that we have to prove when rebutting the retirement presumption. That issue was already decided. I want to speak to our other argument, which I'm sure you'll have questions about. We've argued that the findings or the 2018 amendments to the statute were procedural rather than substantive, and thus can be applied retroactively.
If we agree with that argument, then that means, I believe, that every employee who has rebutted the presumption previously automatically gets cut off at age 72.
Perhaps. Yeah, and I think that may be a harsh result for those people, but the alternative of trying to prove whether or not this hypothetical of whether or not somebody would have worked past age 67, I think is tenuous. And I think that's why the statute was changed, is because this conceit that brings us here is the most difficult thing you have to argue, in my opinion, in front of a compensation judge. And that's why they changed the statute, because, it's so subjective on proving how, if somebody would have worked past age 67. It's, you have a compensation judge say, well, yeah, I think so. Okay. And clearly the statute, when they changed it in 2018, they changed it acknowledging that people are working longer, and this sort of thing is so difficult to prove, we need to get rid of it.
Mr. Borkin, I actually appreciate your, what I'd call the kind of crystal ball argument, right? It's hard to know for sure. But kind of following up on what Judge Quinn had said, in addition to everyone who already has rebutted the presumption, what do you do with all the past cases that have been settled or found that there has been no presumption? You indicate in your reply brief that this would affect very few cases, but you have to agree that there have been, I'll just say hundreds, I don't know for sure, a lot of cases that have been settled or determined based on the laws we're discussing it today. What happens to those cases?
Well, if the case is settled, I don't think anything happens to those cases. I mean, that's the parties have agreed to a stipulation for settlement. Now, if they want to bring a petition to vacate based on a substantial change of circumstances or based on mutual mistake, then they can bring a petition to vacate. But I don't think most of those people are going to either want to open up their settlements again. And if they do, then they can bring a petition to vacate. But that's a small percentage of people, and you might see some additional petitions to vacate, and I think that's fine. And the rest are people who got injured before the amendment changed on October 1st, 2018, turned 67 after that change, and weren't stipulated to be permanently and totally disabled, or were stipulated to be totally disabled. So it's a small group of people. And the ones that have already settled, they can make the decision on their own whether they want to petition to vacate their settlement. But I don't think that's going to be, of the hundreds of people that may have settled those cases, it's maybe 10, 20 people. So I don't think it can be overly burdensome for those people too.
What about the fact that the statute itself, the new statute, or the law passed it, said this is effective for injuries on or after October 1, 2018. And the other statute that says, unless the legislature says we mean retroactive, it's not retroactive.
Yeah, well, you've applied other statutes retroactively that have said that they've gone into effect on the day that they went into effect with regards to the attorney fee issues. And so if a statute is procedural in nature, then you can determine it to be retroactive. And we believe that this statute is procedural in nature because the only benefit, or it doesn't change the benefit, it just codifies the fact that you can only get perm total until age 72, which is something you could already do prior to the statute changing. So that, in my interpretation, is a procedural benefit, and this court has determined when statutes are procedural, then you can apply them retroactive.
Thank you.
Thank you.
Thank you, and welcome.
Thank you.
May it please the court, counsel. Just diving right in with the whole rebutting the presumption thing, and I understand what you refer to, Your Honor, as the crystal ball argument. It is tough. We're putting these comp judges, or we still are, putting these comp judges in a position where they have to sort of anticipate. But that's not to say that they're truly working with a crystal ball. There's facts and there's evidence. And that's what we asked Judge Grove to do in this case, was to consider everything as a whole and come up with an impression as to what seems to make the most sense as far as the intent of an injured worker, Mr. Bauer in this case, upon reaching the age of 67. And, this is discussed in, there's one point in counsel's brief where he references a case and says, well, you need to apply these 8 or 9 factors. That's actually a little bit of a misstatement of the law, because that was in a case where you're using a retirement argument essentially as a removal from the labor market argument in which you might defend against TTD, TPD, or PTD. In this case, it's essentially it's scarring. And scarring sort of prefaces everything. This court says that by using the phrase referencing a previous court, quote, depending on the particular case, that this court has, quote, recognized that each case has its own unique facts and should be reviewed on the question of retirement, and did not intend to set forth a rigid formula. That's actually what this case said again a year later in the Vandervoort case, where it essentially said the same thing, but it said before coming to its decision in Vandervoort, it qualified it by saying given the facts of this case. And then it goes on to discuss the facts of this case, of that case. And Judge Grove did a very nice job. It'd be one thing if she issued an opinion that didn't even acknowledge that there's other case law out there, suggesting that maybe she wasn't even aware of the Vandervoort decision and what the court had to say in Vandervoort. But that's not the way she framed her decision. She head on addressed the issue in Vandervoort, saying that's a totally different issue. And the court was faced with a different situation, and there was a different set of facts in that case. And importantly, she said, in the Vandervoort case, the judge looked and applied this whole sort of neutral versus negative or positive type of analysis. But in essence, found that everything was either neutral or worked in the employee's favor, but yet still denied benefits, raising the issue with the court. Was it really the job search? Was that everything? Did it hinge on that? But that's not what we have in this case. What we have in this case is,
and maybe this is what you're getting at, Mr. Schmeichel, but the Mr. Borkin's argument is essentially Judge Grove focused so significantly on the lack of job search, and you got this stipulation that both parties agreed to, that the employee's PT. Vandervoort seems to say, well, you shouldn't focus on job search if the parties agree. There's no need to job search the guy's PT. If we take that out of this decision, we take out job search, is there anything left that allows us to affirm?
job search, Your Honor, is actually a very small part of Judge Grove's analysis in this case. Counsel, with all due respect, takes sort of a poison pill approach, that because the phrase job search is even mentioned in this context, that I believe the verbiage he used just moments ago was, this court basically has no choice. It must overturn Judge Grove's decision. But a very small portion of her decision actually discussed job search. She also looked at, they paid off their house. I mean, their financial situation, they paid off their house, they paid off their car, they had no dependent children. Actually, the one child who was living with them, they testified that he was fully employed. He's just I don't think we use the term failure to launch, but he was just living with them as kids sometimes do with their parents. And Judge Grove indicated in her decision, one of the factors that they didn't charge him rent, that he wasn't contributing to the household, despite the fact that he wasn't a dependent and had a full-time job. Kind of speaks volumes about the actual financial situation that they were in at the time. And to the extent that she did discuss job search, I think, and Judge Quinn, I believe you were sort of going in this direction, it was sort of in the context of questioning the veracity of their statement that they're in such dire financial straits that but for the injury, they'd have done anything to earn money. That is sort of the context in which Judge Grove seems to discuss the job search. And she's saying, yeah, I mean, a lot of people are perm total disability. They're declared perm total disability. We stipulate to perm total disability, but that doesn't always mean that they absolutely can't work in any capacity. Now, interestingly, in this case, Bauer acknowledged under cross-examination that he was aware that he was, first off, that no medical doctor had completely disabled him. He acknowledged that he felt that he was capable of working at least in some capacity, that he was aware that his Social Security disability benefits wouldn't be jeopardized unless he earned over a certain amount. And yet, even in that context, he didn't search for work. And so I think that this is limited to Judge Grove was sort of testing the veracity of their statements that they absolutely were in dire financial straits. But even if you were to take the whole job search issue out of it, she still relies heavily on, for instance, the wife, Mrs. Bauer, drew her pension, that she had actually retired a number of years in advance, that they travel every single year and spend 5 or 6 weeks in Texas to hang out with their grandkids, that their cars were all paid, and that the Mrs. Bauer had already gone on Medicare. And that was actually sort of the issue when it came up of age 67, what was the plan of retirement. The actual quote in the record is that he was planning to retire at age 67 because they thought, his wife would have qualified for Medicare at that point. He said because of her recent prescription expenses, that he might have to rethink that he would have had to rethink that. But there was a discussion about retiring at age 67. And there was also discussions about what they had anticipated being the case, when they would go on Medicare, the wife drawing her pension, her retiring early, them having everything paid for, no mortgage payments, nothing like that. She said, the judge Grove that is, she said they may have to tighten their budget a little bit. They may have to make some changes, but they can still pay their bills. And they certainly aren't acting like somebody who can't pay their bills.
And so, Mr. Schmeichel, I want to ask you a similar question that I asked Mr. Borken. Can financial stress alone be enough to rebut the presumption? And if so, what do you think that proof would need to be, or the level of financial stress to get over that hurdle?
And I wish I had a specific answer for you on that one, Judge. It's another one of these questions that why this court in Scary and in Vandervoot have specifically said this is so fact dependent, that we rely so heavily on the finder of fact, because every situation is so vastly different. So,
and I'm sorry to cut you off. Do you think the financial stress in this case is significant enough assumption?
I don't. I think that this were, and counsel have brought up, there's, they weren't being evicted from their home. They weren't not making payments. In fact, when I cross-examined Mr. Bauer, I asked him, are you carrying credit card debt? And he said, no, they're not even carrying credit card debt. They're making all their payments. They're paying their utilities. So this is a case where there's a financial crunch, certainly. And I understand that. A lot of people face that, and certainly this is an unfortunate situation for both of the Bauers. But it's not a situation where they're skipping meals. It's not a situation even where they're asking their non-dependent, fully employed son to start paying rent and helping out with some of the bills. It's a financial scare that they're in, and I certainly don't mean to minimize it. But if this situation would rise to the level of, in and of itself, rebutting the retirement presumption, then we really don't seem to have much left of a presumption. And then briefly, I'd like to address the retroactivity argument. Your Honor, you had mentioned MnSTAT section 645.21, which is one of the shortest statutes that I've ever seen. Who says the legislators are they listening to this? They're always too wordy. It simply says no law shall be construed to be retroactive unless clearly and manifestly so intended by the legislature. Well, in this case, offered into evidence was the legislative history right before it was adopted as the change. And the legislative history for this particular change in 2018 specifically states this section is effective for employees with dates of injury on or after January 1, 2019. Not only weren't they silent on it, they specifically indicated that this was not to be applied retroactively for the exact same reason I think we can all imagine, which is the mayhem that would ensue. If this isn't substantive, and I recognize it's a little bit different than, say, changing from 225 to 275 weeks, but it's not far off that. I mean, it does change. For instance, you're giving 5 more years of benefits to an injured worker without requiring them to rebut any sort of presumption, even though as a society we may still look at retirement as being right around 67. Certainly Social Security does. So it's substantive. And so if we start saying this isn't substantive, then how about the PPD, the schedules that we just ramped up very recently? Man, if I got a 25% rating 5-6 years ago and I saw what a 25% rating got me now, I would certainly argue that I should be entitled to that. It would be great for the lawyers because the amount of work that would come up if none of these changes were considered to be substantive and simply being procedural. The amount of work and the amount of legislation the amount of litigation that came out of these cases would be astronomical and it'd be astounding. And I think Judge Grove addressed it best in her decision, which I'm paraphrasing Judge Grove, but she essentially said, or do we go back to 1913? I mean, change is change. Times change, law changes. And I certainly understand from Mr. Bauer, he could say, well, why am I being treated different at one age than somebody else just a couple of years different? That's the very essence of change. Things change, circumstances change, the law changes. It changes all the time in work comp, and it changes for reasons. And we can't go back and apply it all retroactively, nor should we in this situation. I had forgotten to ask up front if I could reserve 2 minutes. And I think I'm at about the 2-minute mark right now.
You can reserve 2 minutes. But Ms. Morgan is out of time. If you're finished, you can say.
I'll proceed with my rebuttal right now. No, actually, I think that Judge Grove did a very nice job of discussing the rationale behind her opinion, addressing head-on arguments that were asserted by counsel in terms of the whole job search issue, explaining the difference between that case, this case, explaining her rationale and justification in this case as to why, again, I'm paraphrasing, but I think she said, overall, this clearly looks like a couple who had retired. They're acting as if they're retired. They're managing their affairs as if they're retired. This looks like a retired couple. And it is sort of that magic ball sort of thing, trying to look into the future. But that's what we've asked our judges to do as triers of fact in these cases. And I believe she did a very nice job.
Rich Quinn, any questions? Gerald?
No, thank you.
Thank you, Your Honors.
Take the matter under advisement and have 90 days to issue our decision.
Thank you.
Do I have 5 minutes for?
You used up your 15 minutes.
Thank you.
Thank you.
Rise, the Minnesota Workers' Compensation Board of Appeals is adjourned. Oh, recessed until 11:30.
Recess to 11.
Yeah, that's the meeting.